You must be aware about the sedition law. But were you aware that the trials on the sedition law have been paused for past 4 years? And finally, Supreme Court says that they can be resumed if the accused is finally willing. But the question is, why was the pause there for? Are there any changes to it now? And why finally Supreme Court has decided to unpause this situation? Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh, and in today's session we are going to understand that what exactly Supreme Court has said. First of all, why the pause was placed, and now why Supreme Court has talked about resuming the trials and all the constitutional as well as the legal dimensions around it. So let us begin with understanding that what exactly has happened. So we have to understand that in our country we have sedition law, that is section 124A of IPC, but now IPC does not exist. Can you tell me in the comment section what IPC has been replaced with? I'll be talking about it in the upcoming discussion itself, but just wanted to know from your end. Now, we had section 124A of IPC, which had the main sedition law, which is the main sedition law. Now, in this context, what did Supreme Court do in 2022? That they said that all the trials based on section 124A need to be paused. Supreme Court gave a very clear understanding to it that the government needs to revisit this pre-colonial era law and look into the utility of it, and till then the FIRs need to be avoided, no new FIRs would be registered, and all trials around it will be paused. Now, what has happened today is that Supreme Court says that because it has been 4 years, there is no finality, even though IPC has been replaced with Bharatiya Nyaya Sanhita now, and similar law is found in Bharatiya Nyaya Sanhita as well. But at the same time, there is no finality that Supreme Court has come around, especially from the government end, that what needs to be done about this. So, Supreme Court said that if the accused person in the sedition law feels that they want to continue with the proceeding, they have the right to do so, and the trials will resume for those people who are willing to continue even without any revisiting or changes made to the sedition law. I hope you have an idea, brief idea, at least the overview that what has happened. Now let us try to break this down, starting with understanding section 124A. Section 124A of IPC, this is our sedition law, which talks and criminalizes hatred, contempt or disaffection against government. Now, based on 124A, the punishment can be life imprisonment or fine and imprisonment both. Now, the factor here is that when the person is talking about government, how it is perceived, especially in this range, seems to be very vague and can be easily misunderstood when the person is probably only criticizing as well. So, that is where section 124A of IPC has been contentious. Historical origin, 1870 was introduced by British, and it was used against freedom fighters such as Mahatma Gandhi and also Bal Gangadhar Tilak. So, this is the very law that we have opposed against, and when we would talk about revamping it, as of now, as I told, IPC does not exist, Bharatiya Nyaya Sanhita does, and in that there is section 152, which forms a fundamental sedition law as based on the new legal framework. Now, moving back to why it was paused, I have already explained that court gave the direction in SG Vombatkere case of 2022 that all the sedition trials will be paused, no fresh FIRs will be encouraged, and no coercive action will be taken under section 124A. The reason I have explained that government informed that we want to re-examine and reconsider sedition law. The only reconsideration it got that it was revamped as section 152. Now, court had a very simple concern here, that when we are talking about the main contents of sedition law, they can be easily on protecting national securities and but very easily on the end of compromising and violating civil liberties and free speech as well. So this is very directly related to Article 19(1)(a), which talks about freedom of speech and expression. So that is why court had this idea, if this is revisited, if this is revamped and this is protected better, then it is a fair idea. That is why the pause was introduced. Now that there was no change to it as such, and government had kept that law for multiple reasons. Government feels that such laws are very important because India faces terrorism, separatist movement, radicalization, anti-state violence, and government thinks that such laws help. Government has this very clear argument that such laws do help in ensuring sovereignty, in maintaining unity and integrity, and also preventing all the violent secessionist activity that take place across the country. So government decided to keep this without any change, as I mentioned, in section 152 of Bharatiya Nyaya Sanhita. So government has also given their argument which supports any sedition type provisions which are present. And that is why we find the section 152. And the government has been very clear that when we are talking about freedom of speech, which court wants to ensure that this is not being curtailed, freedom of speech cannot include any violent rebellion, armed uprising or incitement against nation. If it comes into it, it needs to be addressed through harsh measures such as the ones which are given in section 152. That is the point where we cannot focus on civil liberties and compromise on national security itself. Now another question arises that why are we placing so much emphasis on this? Because sedition, as much as it is important for national security, it is equally important for civil liberties, because this is where it gets controversial. When we are talking about sedition, we also need to know that the law which is present here, it is very vague and broad. And that is why it can be easily misused for activists or journalists or students, and it automatically generates a fear to not be able to speak against the government. It generates self-censorship where you stop yourself from saying certain things because you are worried that you might be labelled as the anti-national or as anti-government. And that is where the problematic words or vague words such as disaffection, subversive activity, which can be interpreted so widely and wrongly as well, are the reasons that there are major concerns around sedition law. And this is not what just critics think about. This is something Supreme Court, not recently but back in 1962 in the Kedar Nath Singh versus State of Bihar case, Supreme Court ruled that criticism is not sedition and the government needs to focus on the clarity of it. Only incitement to violence qualifies as sedition, and government needs to be very clear on this. So as of now, we do get to see that section 124A is not present and it is being reconsidered per se, but such provisions are present in Bharatiya Nyaya Sanhita and they need to be understood clearly so as to ensure that safeguards are not misused. So Supreme Court is trying to give back to the accused so that they get the right to trial, speedy trial in this situation once civil liberty is being ensured. Can you tell me in the comment section which particular fundamental right is related to right to speedy trial? Now on this note, I'll be ending today's session. I'll be leaving you here with a prelims practice question, very straight, easy question. Let me know the answer to this in the comment section. Thank you so much.